These are appeals in the matter of Robertson and Google.
My Lords, good morning.
Yes,
I appear on behalf of the appellate Google LLC in the main appeal with Mr. Roberts, and my own friend Mr. Bock appears on behalf of Mr. Robertson.
just one moment while I just check my stationery. Yeah, thank you.
Just to check from a housekeeping perspective that you've got everything. There are two appeals, as you know. There's what I'm going to call the main appeal, and then there's the costs appeal brought by Mr. Robertson. Those are accommodated in the two bundles which you should have. The core bundle, which deals largely with the main appeal, and a supplemental bundle in which you'd find, for example, the grounds of appeal and the costs appeal. And then there's one authorities bundle.
Yes, that's what we originally had, but you're about to tell us about the late arrivals.
And there's, I was going to say that you should also have skeletons from
Yes.
both parties on both appeals, so two each.
Yes, the skeletons on the main appeal are in the
core bundle.
core bundle.
The two skeletons that were filed after permission was given on the cost appeal are in the supplemental bundle.
Oh, are they? I've got.
Yes, they are.
Very well.
And then.
But I've also got them loose, but that's just.
Oh.
Yes, no, okay,
maybe,
it's all becoming clear. Yeah.
Maybe they were emailed as well.
Yes.
And then there's the matter which you've mentioned, my lord, which is that Mr. Bock served late an additional skeleton argument, I think on Friday evening, which relates to the costs appeal. We're not aware an application has been made to put that in. It included 5 authorities and raises a new point.
Yes.
I don't know, just to let you know our position on that, Mr. Roberts, who's going to be addressing you on the costs appeal, is able to deal with this late arrival if that's what the court wishes to do. But the short point is that Google's position is that it is new, there's no permission for it, it wasn't raised below. It raises a point about jurisdiction in relation to Part 11 of the CPR, which ought not properly to be considered at late notice and in a costs appeal, and that the authorities which have been put in don't support the proposition anyway. So you can see
yes,
where we're going with
I
that.
can quite see why you feel a bit narked about this and the way it's happened. I'm not sure, I haven't worked this out because this material came in late and I hadn't a proper chance to digest it. Luckily, both my lords have. But I'm not sure that permission under the rules of any kind is required. It's effectively a new point,
Yes.
and you do require permission with a small p to take a new point in the Court of Appeal, but if it's a point of law with which the parties are able to deal, however cross they may be that it wasn't taken earlier, we tend to grant it, particularly if it goes to jurisdiction.
Yes.
And I think I can say now that we would be minded at least to hear argument. It may be there are hidden difficulties, in which case we will reserve our final position on it. But I think we would like to hear argument about it.
Yes.
And the way in which the argument is structured is something on which you may be about to tell us.
Well, as I say, we came prepared to deal with it in this scenario, so that's fine. The caveat is that we haven't had time to do deep research into it, but as your lordship points out, that there may be ways of dealing with that anyway, in due course. But we can certainly deal with the argument, and after Mr. Bock has made it on his costs appeal.
Yes, you although it has implications for the other appeal as well, or for the appeal, you would prefer to deal with it by way of response. You'd like to hear it developed.
Most certainly, yes, most certainly, because I think that I mean our whole appeal, qua the main appeal, is obviously not focused on Part 11.
No, I see that.
And we're not we don't see it as an appeal that raises an issue in relation to Part 11.
No.
Because it wasn't raised below and the judge had no regard
Well,
to
I
it.
see that. So it is a new, but if the point is good, and you say it isn't, it does it not trump the point in the main appeal?
Well, we would say it's not that simple.
No. Okay. Well,
And I think that one needs to develop the main appeal submission.
certainly. Yeah.
deal
Well,
with the way-
let's. I just wanted to get a general overview. I think I at least, my lord may be in a better position, but I at least will. If I ever make intelligent observations about it, will be in a better position to do so after I've heard it developed.
Yes,
So off you go, really.
my lord, I'm grateful. Just on.
I'm sorry to interrupt. Could I just find out the authorities that are referred to in the speaking note? Are they in the authorities bundle?
A separate bundle was filed by Mr. Bott
haven't got-
containing those.
Oh, yes, I have, but haven't.
I just got the
Well, my lord has a hard copy, and since he is using it on screen, he's sharing it with my other lord. So that's solved. I did have a copy of the new authorities, which I have skimmed through but have foolishly left behind. Is there a spare copy in court? If not, I'll ask.
Perhaps if I just hand your lordship my own copy.
Well,
It's not
that'll just
annotated.
cause inconvenience in the long run. What I might do is I think the most efficient thing is I might ask my judicial assistant who's in court to could you just go back to my room and it's beyond my desk. It's 5 authorities not in a folder but just Treasury tagged, and it'll have the name of the case on the front. I think should do. But thanks for it. That was foolish of me, but I'm afraid that's what happens when stuff comes in late. Judges lose it. Right. That answers my lord's question.
sorry.
Just on timings, I hope that you received the parties' agreed estimates for how to spend the time today, and if we go into tomorrow.
Well, if I did, I didn't.
Shall I just tell you what they were?
Yes, and the case has a 1.5 day listing. Even with this extra complication, I'd have thought that's pessimistic. But you think you'll need the full 1.5 days, do you?
No, we think we can do it. We should be able to do it in a day.
Yes.
I will obviously cover quite a bit of ground that will mean that Mr. Bott doesn't have to
Right.
on the background. And I know that we're going to be treading over territory which is very familiar to all my lords, and so I can
Yes.
take some of it.
We I can say we're confident. We have read the papers fully on what we thought the appeal was primarily about.
Yes.
And so you can take that pretty lightly. We may need more once we get to Order 11 at a later stage. We may need Order 11. Sorry, there's me showing my date.
Old days, yes.
My age.
Part 11.
Once we get to jurisdiction, I think we'll have to go more slowly.
I'm grateful. Well, the timings were that I have 2.25 hours, which
Yes.
I hope I won't need, but and then Mr. Bott has 2.25 hours, and that takes us to 4 o'clock today. And I doubt that half an hour is needed for reply, but that's how it was, and then the cost will be dealt with tomorrow. But as I
Oh,
say,
I see. Well, okay, yes.
Parties are ready
I
to deal-
thought I still hoped that that the appeal and the cross appeal could be dealt with.
yes, I mean,
Let's see. We'll see how we go. We've got tomorrow if we need it.
so just a quick, what I'm going to do, the structure of my submissions will be, I'm going to do a very brief introduction relevant to both appeals. That will include very briefly the background facts and the procedural history. Then I'll move on to the main appeal itself and ground 1, which is obviously the main ground. In other words, the whole question of the interrelationship between CPR 7.63 and 6.34.2. And so forth, and then dealing with why we say the judge was wrong in his reasoning and in his decision on that. And I have 4 main submissions as to why he was wrong. And then I
he
had
has
ground.
plainly made in his own judgment the reasons why you say he was wrong.
Yes.
But you say
Well,
he sort of
we've
stuck
developed them just so
Yes.
that there's a bit
Okay.
more focus on the rule, the structure of the rules, perhaps, and the construction of the rules. Than there
Okay.
was below.
Let's get going.
So the first issue in the appeal, this main appeal, as you know, is arising under the ground set out as this. Did the judge err in finding that CPR 7.63 was inapplicable in this case, and that the application made by the claimant was governed solely by 66.342b and conventional relief from sanction principles? The second ground is, judge applied 7.63, would he have had to refuse the application by the claimant and dismiss the claim because the claimant had not met the conditions in 7.63b and c? The issues on the costs appeal, as I say, are in the separate grounds of appeal in the supplemental bundle. The main appeal has leapfrogged here, of course, from Central London County Court, because as Lady Justice Andrews put it in granting permission to appeal, which is at tab 8 of the core bundle, the issue identified is one of general public importance, and there's at least one decision at High Court level which would be binding on any circuit judge hearing an appeal and would almost certainly lead to the appeal being dismissed. We take that also to reflect the view of the Deputy District Judge below, now as I understand it, a judge, as whom I shall call judge, in granting permission to appeal, when he said, this is tab 7, page 87, paragraph 14 of his consequentials judgment, it might be said that the law in this area requires clarifying, as it might be said there's a conflict between the principle underlying relevant rules on the one hand, how those rules have been interpreted to date on the other.
Thank you. I'm so sorry.
Sorry you were troubled. I was less inefficient, or my clerk was wholly efficient. I had it all along. Right, keep going.
And just carrying on with this quote from the consequential judgment, in particular, the judge said, as Google's counsel, Ms. Evans points out, 7.63 appears not to have been drawn to the attention of the High Court in any of the cited cases, and no consideration has been given to the
Well, we have read all
consequences.
this, yes.
Yes. And it's the point
So-
my Lord just made about our submissions in paragraph 56. I'll come on to address the first ground of appeal shortly, and why, as I say, Google says that the judge got it wrong in not applying 7.63. But as I said I would, a brief summary of the background facts.
We are
Unless you
aware
don't
of them,
want
but
me-
there may be some you particularly need to
Well,
emphasise.
there are not very many.
Okay.
Claimant had channels on YouTube on which he posted his own content, including on subjects like race and the decline of the West, so-called. He said they were a right-wing perspective. He had thousands of followers and successfully monetized the channels. From 2018, he claims Google, which is the operator of YouTube, began to shadow ban his channels, meaning not recommending the content to others, and then took steps to demonetize them and finally terminated his channels in February 2021.
Well, we do. I'm sorry, we do know all this, and this is merits of the claim or the nature of the claim aren't really material at all, are they?
No, okay. I'm doing it partly just for the others in court, but I will move on. I will move on, but what I do want to do though is focus on what are, I think, points of common ground that arose in the proceedings, because that will be relevant to
Yes,
stress these for the analysis. I think that there are 13 of them, but that's just because that's how I've broken them up. The first is that the claim form was issued by the claimant by his direct access counsel, I believe, 7th of October 2021. There is no reference on the claim form, which is at Core Bundle tab 9, page 94, to either CPR 6.33 or 6.36. The former, of course, allows for service out of the jurisdiction on a foreign defendant without the court's permission in certain defined situations only, whereas 636 service out requires the court's permission. The third point is that the address for service was correctly identified on the claim form as being Mountain View in the United States. The fourth point is that the claim form, particularly the claim of the response pack, which were received by Google at Mountain View, were received on the 5th of April 2022. Note that this was 2 days before the expiry of the 6-month service period under CPR 7.52, which I'll return to that provision shortly. 5th point, the claim form and the particulars of claim and those served documents were not effectively served on the 5th of April because Form N510 had not been filed by the claimant at Central London County Court or served on or received by Google, contrary to the requirements in CPR 6.34.1. As my lords know, Form N510 is a statement in which the claimant certifies, with a statement of truth, that the claim comes within one of the defined circumstances in CPR 6.33, for example, that there's a relevant contractual jurisdiction clause stating that any disputes be heard in the courts of England and Wales. And therefore, the claimant doesn't need the court's permission in that scenario, unlike in a 6.36 scenario. The 7th point is that Form N510 was not filed at court or sent to the defendant until 22nd of February 22, and then only after the defendant's solicitors in London.
22nd of February.
Sorry, did I say February? I meant April, 22nd of April.
Yeah, sorry.
I'm
yeah,
sorry.
22nd of April.
2022. And that was after Google solicitors in London had informed the claimant that he had failed to comply with CPR 6.34.1. By this time, 22nd of April, the 6 months permitted for service of the claim form under CPR 7.52 had expired on the 7th. This meant that the claim form had not been served within time. Now, all of this is, I think, common ground. 9th point, as a result, on the 22nd of April 2022, the claimant issued an application under CPR 6.34.2b for relief from sanction for the failure to file and serve the form and to, quote, render the service effective, is the phrase on the application notice, and in the alternative, if necessary, again from the application notice, to extend time for service so service can be re-effectuated with Form N510 enclosed, closed quotes. And so that must have been an application intended to be brought under 7.63. Ultimately, after several adjournments, the hearing was held on the 17th of May 2023, and the defendant, as you know, opposed the application under 6.34 on 2 main grounds. First, that the claim was not one which properly came within 6.33 because the contract between YouTube and the claimant could not be said to extend to a claim under the Equality Act, which was one of the 2 causes of action relied on, the other one being breach of contract, which is less controversial. In those circumstances, it was Google's submission that the claimant had needed permission to serve out. Now, the judge rejected that, what one might call the jurisdiction argument, and it is not the basis of the appeal. The second ground for resisting the 6.34 application was made by Google was that the claimant could not remedy the procedural error of failing to file and serve N510 by a relief from sanction application under 6.34.2b because the claimant required an order extending time retrospectively to serve the claim form under 7.63 because time had expired on the 7th of April before the claim form was effectively served. The judge ultimately accepted the claimant's position, but not, as my Lord Justice Underhill has already pointed out, without some pause for thought about the submissions that were made for Google about the consequences of not applying 7.63. So he granted relief from sanction allowing the effectively allowing the error to be corrected by some form of waiver, if you like, and the claim was deemed served on the 5th of April. So turning to the basis of the appeal, very quickly I'll just highlight the bits of the judgment which are under appeal in relation to ground 1. It's fairly obvious what they are. That's at tab 6 of the core bundle, starting at page 51. And if you turn to page 71, paragraph 50, where the judge identifies what he describes as the real issue of contention as being the stage at which the court can grant permission under 634(2)(b, but although in fact pausing there more accurately would suggest the question is, can the court grant permission under 6.34(2)(b on these facts, thereby allowing for effective service despite the failure to file the form, and even where the time limit of 6 months the service had expired. The judge goes on from paragraphs 51 to 55 to cite from a few first instance decisions, largely through the citations found in the Athena Capital case, because those were cases which had addressed an aspect of a failure on the 6.34(1), either a failure to file the form or a misticked box or some such. But the point about those cases, which is one of the reasons why Google says the judge went wrong, is because none of them were addressing the situation in this case where you have time expired. In other words, the 6 months having expired, but no application in those cases under 7.63 appears to have been made, and there's no reference to that provision in any of those cases. I'll come back to Athena a bit later. In 56, as well, Lord Justice Underhill pointed out, this is where the judge, we say significantly, admitted that he had been what he described as inclined to agree with the position that the defendant had taken as to the relevance and applicability of 7.63. And he then cited the 3 principal reasons which Google had advanced in making that submission, which again I will come back to. We say that this is where, after paragraph 56, you can see the judge went wrong, because in 57 and 58, he went against his better judgment in our submission in finding, with rather thin reasoning with respect, that this was a relief from sanctions situation, and CPR 6.34(2) was a sufficient answer for the claimant. His reasons were, as I say, short, and we submit flawed. In summary, in 57, he said that it seemed clear from the first instance authorities he cited that do exist on the subject, in quotes, that the approach of the courts to issues arising under 634 is to resolve them by reference to that rule and the test for relief from sanctions, irrespective of the timing of any such application under 634(2)(b, i.e. even when time for service has expired under 7.5. 2 points in passing on that. He said the first instance authorities that do exist on the subject, but he then went on to accept that they didn't touch on at all or consider 7.63. So we would suggest, perhaps it's a small point, but those are not authorities that exist on the subject.
Well, even if they were, they aren't authorities at our level, so
Um,
I'm not very interested in them, except insofar as they're a useful way into particular points.
And so in 58, his conclusion was that notwithstanding the acknowledgement of the force of some of our arguments, he decided that 7.63 did not apply. I said we had four main submissions as to why we say that that decision by the judge was wrong.
Yeah.
The first, I'll just tell you what they are in brief, and I'll come back and develop them. The first is that CPR 7.5 and 7.6 are the only specific provisions in the CPR that deal with how long a claimant has to effect service of originating process and the circumstances in which time for service for 4 or 6 months can be extended. Those rules apply to service of every Part 7 and Part 8 claim. And CPR 7.63 is strict as to the conditions to be met for retrospective extension of time where the service deadline is missed. It's a high bar. So that's the first reason, and I will come on to seek to analyse in a bit more detail those provisions. The second is the other set of the provisions, the 6.34(2)(b), which we say is only concerned with effective service under that specific rule, namely in a CPR 6.33 situation, and that is where the claimant is allowed to self-certify in form N510 that he does not need the court's permission under 6.36 to serve out of the jurisdiction. So in a nutshell, we say it's a narrowly focused rule with a particular purpose born of the exceptional provision of serving out without the need for permission. And again, I will come back and develop that by reference to the rule and some case law. The third main reason which we advance is that which we relied on below, which the judge accepted had force. In other words, were it otherwise, i.e. that the claimant contends that 634 is a self-contained code, the consequences would be, as we submitted below, which is that first it would allow a claimant who had used the 6.33 provision, but who had left it late and so missed the CPR 7.5 6-month deadline, to bypass the strict requirements in 7.63 B and C that apply in every other scenario.
Isn't that really just a consequence if you're being right, if you are right on 1.1? It's not really a distinct point, is it?
It ties into the second point, which has more of the flavour of a policy reason why these the consequences of the decision that the judge made, if he's right, would have to be taken into account. Wider consequences as to the coherence of the rules, and the second reason to make good that point, which is the second one we relied on below as well, is that if it were the case, as the claimant says it is, it would put a claimant in a more favourable position than a claimant who had not had to or been able to use 6.33, either because the service was within the jurisdiction, so no permission or form was required, or because the defendant was outside the jurisdiction but leave was needed under 636. Those hypothetical claimants and defendants, the claimants would have to satisfy 7.63 if they missed the service deadline of either 4 months if they were serving in the jurisdiction, or 6 months if they were serving outside the jurisdiction under 7.6, sorry, under 6.36. So you would end up having an advantageous position potentially for somebody in this claimant's position on his argument, because he would be able to miss his deadline of 6 months, having failed to file the form and having failed to effect effective service, and yet using relief from sanctions principles, he could get the court to do what happened here, which is to let him effectively extend the time for service of the claim form beyond the 6 months. Whereas the claimant who doesn't have to use 634, because the claimant isn't bringing a claim that comes within 633, that claimant has to apply to extend under 7.6 if time is either about to run out or has run out, either prospectively or retrospectively. So the consequences, and this is why I say there's a policy
Are you
aspect.
making the point or trailing it?
Well, I'm now developing it more than I intended to at this stage. I'm going to...
Well, that's always the problem. Counsel say I'm just here to tell you what my points are, and then it's a problem for noting.
I accept that.
Okay,
but if it helps, those 2 points are ones which I don't intend to develop much at the end anyway.
Right, okay.
I think they speak for themselves. I mean, they are observations about the consequences of the decision that was reached, if it's right. Now, it begs the question whether we say it's a reason why it's not right, because these consequences point to a lack of coherence in the approach to the respective rules on service in the jurisdiction and out, and even between 633 and 636, giving a 633 claimant an advantage. I think I probably don't need to come back to that point, but that's the third point.
Yeah.
The fourth and the last main reason of submission as to why the judge went wrong is that, and we've touched on this, is that in any event, the judge was wrong to find that the cases that he cited in paragraphs 51 onwards in his judgment, Athena and so forth, were an answer to the arguments that he had heard on the facts of this case. None of the cases, as I say, appear to have been examples of service outside the 4 or 6 months, save possibly Athena, which had very unusual facts. But in any event, none of them, and they were, as you say, at High Court level, addressed 7.5 or 7.63. So we say they're not really of any assistance.
Okay.
So now I'm going to come back and develop those submissions a little bit more, if I may. Going back to the first one then, which is about the rules in CPR 7.5 and 7.6, which it seems helpful to seek to construe so that one can analyse their reach and whether they are applicable in this situation. The authorities bundle has photocopies of the main ones, maybe that we need to look at the white book in due course. But if I start with 7.5, that's at tab 3 of the authorities bundle. Or if I don't know if any of you are looking at the white book itself, it's page.
Well, not at the moment.
I am, of course, looking at the white book itself, because obviously my name appears on the spine, so I feel duty bound so to do. But that's simply a personal preference.
It's page 381.
Yeah.
The court, I know, is very familiar with these rules, and I don't want to spend longer than necessary on them, but it's very important, we say, to get this context right.
Spend whatever time you need.
7.51 sets the time limits for service of a claim form within the jurisdiction. It's 4 months after the date of issue of the claim. It also sets out the methods of service. Those are not relevant here. Clearly,
Well, strictly speaking, what 7.5.1 is about is only about time limits. It refers to methods of service, but only because the time limits vary according to the methods of service. It's not prescribing methods of service. That's done somewhere else.
Yes, and it just sets out the method below so that the timing can be worked out.
Exactly, but it's only its operative effect is about time limits only.
Correct. We certainly don't dispute that.
Yeah.
It is clear that 7.51 applies to all claims brought under Part 7 or Part 8 jurisdiction, if I can use that phrase. We know that it also applies to Part 8 claims because CPR 8.2, which you don't have a copy of, but it's page 411 of the White Book, makes clear that Part 8 claims must be served in accordance with 7.5.
Just give me the reference for that again.
It's page 411.
No, but which rule? Sorry, Part 8.
8.2.
8.2. Yep. Okay.
Then turning to look at the sub-paragraph 7.52. This sets the time limits for service out of the jurisdiction at 6 months, and it says in accordance so the claim form must be served in accordance with Section 4 of Part 6 within 6 months. Part 6, of course, encompasses 6.33 and 6.36.
Well, hang on, I'm just sorry. What's Part 4 of
Section
Part
4?
6? What? Just have the.
It's where the foreign defendant procedure begins, I think. So.
633 and 636 come in Part 4, do they?
They do.
What's the heading of Part 4?
I think. Sorry, it's okay. So it's page 281. The heading is Service of the Claim Form and Other Documents Out of the Jurisdiction.
Yes, I see. Oh, sorry, it's all coming back to me. Yes. So Part 4 is the out of the jurisdiction bit.
It's the out of the jurisdiction bit, and it includes, for example, not relevant here, but just for example, 6.32 as well, which is the service provisions for Scotland and Northern Ireland.
Yeah, thank you.
So the reason for dwelling on in accordance with Section 4 of Part 6 is partly because my understanding is that Millennial friend Mr. Bock relies on that to suggest that somehow that means that the provision in 6.34 can be treated as he says it should, which is as giving power to the court to give permission that would effectively bypass 7.63. We say that's an incorrect reading of those words.
Surely the point is a more simple one, isn't it? That where 634 refers to giving permission, the issue between the parties is which test or which set of rules do you look at for the question of that permission. You say it's 7.6. He says it's relief from sanctions.
Yes, and what I will come on to say is in a bit more detail about 6.34 is that 6.34 is very narrowly focused on itself.
I follow that additional point, but I mean that's the broad issue.
Yes.
It's unsurprising, you would say anyway, that section Roman 4 of Part 6 is referred to as 7.62 because those are the rules dealing with service out of the jurisdiction.
Right. Yes, I mean, in accordance with Section 4 Part 6, we say means no more than that service out of the jurisdiction is to be effected in compliance with the rules in Part 4 of Section 4 of Part 6. In other words, when we come on to look at 633 and 634, that must be done by filing this form. So we will come on to look at how 6.34.2 affects that. 7.6, which is on the next page at 383, under the heading Extension of Time for Serving a Claim Form. 7.61 says the claimant may apply for an order extending the period for compliance with Rule 7.5. That's not difficult to understand. 7.62 is described as being the general rule. And it's that an application to extend the time for compliance, in our case, that's in other words to extend the 6 months, must be made within the period specified by Rule 7.5, or when orders be made under this rule, and that doesn't apply here. In other words, what subparagraph 2 makes clear, and all the authorities are at one on this, is that a prospective application to extend time before the time expires is the general rule. And to reinforce that, when one comes to look at the important subsection 3, it is plain from the very different language, and subsection 3 deals with retrospective applications, the test is very different. So 3 says if the claimant applies for an order to extend the time for compliance after the end of the period, which is the situation we're in here, the court may make such an order only if A doesn't apply, the claimant has taken all reasonable steps to comply with Rule 7.5 but has been unable to, and in either case has acted promptly in making the application. I don't think there's much of any dispute that the claimant can't bring himself and didn't seek to within 7.63b.
That's not expressly conceded.
Yes. So it's clear that there are strict conditions for granting an extension after the expiry of the 6 months. And I don't think I need to take your lordships to examples of cases where that high bar has been applied. There's a useful smattering of them, for example, in the White Book on page 385 to 386 in the notes at 7.6.3, nearly all of which are examples of cases where the claimant was refused permission to proceed after making a retrospective application. And if one just picks out, for example, at the top of 6, an example of which is the case of Chair and Fairclough, which was a 6.36 case of service out in Saudi Arabia, where leave had been granted by the master. But even though one might say that the error there was, as they often are, an error by the legal representatives or their misunderstanding of the rules, nevertheless, the claimant was visited with the outcome, which was that there wasn't a good reason for extending time. And you see there the statement that the claimant solicitor should check within the 6-month period from issue of the claim form whether service has been effected, and if not, apply prospectively for an extension of time. A retrospective application would be considered, and then they cite the conditions. It wasn't in that case.
Well, another example which isn't here, but is in the bundle, is good law, which was not actually about 7.6, but where it was held that the principles of 7.6 should apply.
Yes.
And that was another case where a frankly trivial or technical error by the solicitor was held not to fall within 7.63b principles. So I don't think you need to.
No, I mean, that's why I said I didn't think I needed, and I'm going to go to good law briefly at the end.
Yeah.
On a slightly different point, but there we are. So the bar is high, and the key points about 7.5 and 7.6 and how they operate are that we say they are the only provisions in the rules that govern the timing of service. And if you don't apply prospectively and you leave it until after time has expired, you have to show, let's use a shorthand, a good reason, which in 7.63b is translated into showing that you took reasonable steps but were unable to comply, i.e. within time, and promptly and so forth. So although the cases are fact sensitive, the principle is very clear that what you have in 7.5 and 7.6 is what's being described as a specific subcode dealing with service. And that's a description which you see in the ideal shopping case, which I just want to go to next, if I may, because it has some quite
Can
useful...
I ask, was ideal shopping referred to the judge?
Yes, it was. It was in the
And
scope.
was good law?
Good law wasn't.
Thank you.
Okay, we'll take us to ideal.
So ideal is at tab 12 of the authorities bundle, so it's Court of Appeal decision. In some ways, the most important principle that comes out of this case is that the specific subcode of 7.5 and 7.6 related to service can't be overridden by the general power in CPR 3.10. I hope to show that CPR 6.34 is rather like 3.10 in the sense that it is not part of that specific subcode in 7.5 and 6, and it can't be used to sidestep 7.6. And there's some helpful observations in ideal shopping. So the ideal shopping facts are very different. It was a competition law claim, service in this jurisdiction against defendants here. On the last day for service, i.e. the 4 months, and just before service, the claimants sought to amend the claim form and then filed that electronically under the relevant electronic protocol that was at that point relatively new. But the court didn't return the amended claim form sealed in time for it to be served within the 7.5 period. It was only returned sealed some days later after time had lapsed. But the claimant served it in an unsealed form on the last day. So the question was whether, there were 2 questions. Was the service of the unsealed form effective service? The answer is no, and I don't think we need to go into why that was. The second question, which is more pertinent here, is could the power in 3.10, the power to remedy an error or failure, could that be used to retrospectively correct this and allow the service to have been effective? Or would that be bypassing the specific rules of what's called the specific subcode of 7.63? And the answer was that it would be bypassing it impermissibly. And so the service would not be made good through that mechanism and that application. The court will read the head notes, no doubt. The procedure is described in paragraphs 17 to 22, and you'll see that rather like in the good law case, there are references to rule 6.15, paragraph 20, as well as to 7.5 and 7.6, and 6.15 being another service provision which governs and is the only rule that governs allowing claims by allowing service by an alternative method, and so forth. And I'm going to come back to 6.15, if I may, in a little while. You'll see that next at 39 to 40, the court addressed the reliance by the claimants on CPR 3.10 as a basis for allowing the court to grant retrospective dispensing of service under 6.16 or extension of service under 7.63. And at 40, Sir Julian Flo, the Chancellor, said, on the basis of, and this is the Vinos line of authorities that he's referred to above, 3.10 is to be regarded as a general provision which does not prevail over the specific rules as to the time for and manner of service of the claim form. And then you see at paragraph 51(2, under the heading grounds of appeal, you see the issue of appeal included that the judge was wrong to follow Vinos' line of authority on 3.10. That was rejected by the Court of Appeal, all three Lord Justices, 144, who held that the claim forms were not served. There was no effective service because they had not been sealed. Critically, at 145, on page 283, there's an analysis of the scope of Rule 3.10 and whether in principle was available on the facts, which says it's important to analyse correctly what is the error of procedure which the claimants are asking the court to remedy. And that, of course, is a relevant question in this case. They're in substance asking the court to treat the service of unsealed amended claim forms as good service and to dispense with the requirement for any further service. Those are matters to which 6.15 and 16 are applicable. Yet those applications were refused. And then this, it's also important to note that none of the claimant's applications included an application for an extension of time under Rule 7.63, the service of the sealed amended claim forms. Yet, in seeking to remedy the defect in service, the claimants are, in a very real sense, seeking to achieve the same result as would a successful application under Rule 7.63. Now, we stress that last sentence because although I have to make good that 6.34b, 2b, is to be treated analogously to 3.10, or there's another reason for not treating it as self-contained, this sentence applies to this case insofar as the bypassing mischief is identified. And that is predicated, of course, on the crucial importance of Rule 7.63 as the one way of policing service within time where the application is made after time. And then you have at 146, it says it therefore follows that the claimants are asking the court to do the very thing which Vinos and the line of authorities does not permit. The general provision in 3.10 cannot be used to override a specific provision, here 6.15 or 6.16. And then dropping down likewise, since the claimants could not have satisfied condition B of 7.63, as they could not have shown that they'd taken all reasonable steps to comply with 7.5, so forth, they cannot be permitted to use 3.1 to bypass those requirements. And just to elucidate the references, the constant references to Vinos, at 147, you'll see that Sir Julian Flo Chancellor says this is clear from the judgments in Vinos of May LJ at paragraph 20. And if you go back to paragraph 69 of this judgment, page 263, that paragraph of Lord Justice May from Vinos is set out. I would just invite you to read it yourselves. And then, sorry for jumping around, if you can go then back forward to 150 in Ideal Shopping.
Sorry, go to
150, paragraph 150, page 285. And this is where I have obtained the phrase specific subcode. You'll see it's at the the end of that paragraph. So it starts, the remedying of the error under Rule 3.10 would still involve bypassing Rules 6.15, 6.16 or 7.63 and is thus not permissible. Provisions on the service of originating process in rules such as those form part of what Lord Justice Peter Gibson described in Vinos as a specific subcode dealing with service and cannot be overridden or bypassed by the general power in Article 10. And the same point really comes up is made in 151. Lastly, on this authority, over the page, paragraph 155, which is citing Lord Sumption in the Barton case in the Supreme Court from 2018, and rejecting, where he's rejecting the proposal that the court could exercise its discretion, and in particular the warnings set forth by Lord Sumption, where he says about a case where the claimant doesn't apply prospectively to extend time. Where a claimant leaves the filing of claim forms until the last day for service, it courts disaster and has a limited claim on the indulgence of the court. This is all the more so where the failure to serve sealed amended claim forms was due to a mistake on the part of the claimant's solicitors, as in this case. And then it goes on to say that the number of steps the claimant's solicitors could have taken to avoid the problem which occurred.
But that's presupposing that 310 may apply.
Yes.
Yeah, he's doing this explicitly. One sees from the earlier paragraph, he's doing this specifically in the alternative in case he's wrong.
Yeah. But the reason I've highlighted 155 principally is because the refrain about the court not indulging on such mistakes, particularly by legal representatives, that result in deadlines for service being missed, is repeated time and time again. And it's, of course, it's consistent, or it's all of a piece with the high bar in 7.63, which is that you, unless you can show reasonable steps were taken, you're not going to persuade the court that you should have that, perhaps not exceptional, but anyway, rather unusual indulgence. I just want to turn quickly to look at the rule in 6.15, which has come up in this judgment, and it will take me to the good law judgment. I think it's helpful to consider a point that emerges from good law about this other element of the specific service subcode. We've seen from Ideal Shopping that 6.15 and 6.16, along with 7.63, are part of the service subcode. And whereas CPR 6.15.1, you may want to turn it up, I'm afraid it's not in the photocopies, but it's page 261 of the white book.
Sorry, well, I haven't understood. It's not in, I've got good law in tab 26.
Yes,
of
I'm
the bundle.
sorry. It is good law is in the bundle at tab 26. I was just going to go first to the rule itself,
Oh, I see.
because it may be easier just to look at it in the white book. So it's page 261. This is rule 6.15.
Yeah.
That rule gives a specific power to the court to permit service by an alternative method, as I said before, or at a place not otherwise permitted. But this may only be done if the court considers there's a good reason to authorise that, which is made clear in sub 1 of that rule. It refers to the need for a good reason. So in other words, it's not something to be waved through with no consideration as to why the claimant missed the deadline, and whether there's convincing or good reason. In other words, put another way, it's not enough that it's a procedural error. Note also 6.15.2 provides the specific power that the court has to make an order that steps already taken to bring the claim to the defendant's attention by an alternative method or place is good service. And we submit that, so those two, the provision in 6.15, 1 and 2, are equivalently found in the court's other specific power in this subcode, 7.63b. In other words, that you only permit either the time to be extended or, in this case, an alternative method of service if the claimant has taken all reasonable steps and so forth to comply. In this case, with with service under 7.5.
Yeah.
And it may sound that, as if this is slightly tangential to the point, but the reason it's not, in my submission, is if you do go now to the good law judgment, which my lord was, of course, in, quite apart from the significance of the fact that this judgment, which is a practice note, makes clear that even for judicial review, 7.63 is the guiding set of principles for, particularly for retrospective applications. But if you go to paragraph 98 in my lord's judgment, my lord gives two types of case where it said it would be typically just to retrospectively validate non-compliant service, notwithstanding the loss of the defendant of a limitation defence in that case. And it's the second one which I suggest is relevant for our purposes, and it's where a claimant has taken reasonable steps to effect service that has been thwarted by some unforeseen external occurrence. And it goes on to make the point that these are reflected in Lord Sumption's observations in Barton, which I've pointed to in a slightly different paragraph in the other case. That's solicitor's responsibility. But the reason I stress this is that that phrase or concept of the claimant having to take reasonable steps is the wording from 7.63.
Yes, I mean, I don't appear to say it in my concurrence, although as you say it's implicit, but doesn't Lady Justice Carr explicitly say 7.63 principles to apply?
Yes, she does.
41,
I'm grateful.
again at 79.
Yes, thank you.
Yes.
So the point I'm making, in addition to the point about 7.63's universal application there, is that but within this service subcode, the relevant parts, which are 6.15 and 7.63, both have a test set out within them as to what is required of the applicant who's asking the court's indulgence for retrospective permission. And they both amount to the same thing, which in shorthand is a good reason. It's called a good reason in 6.15.1, as I've just shown. In 7.63, it's described as taking reasonable steps to effect service. But what I'm seeking to show by taking the court to paragraphs 98 and indeed 99 of my Lord Justice Underhill's good law judgment is that that test is taken as being part of the core justification that a claimant has to bring to court and make good in seeking the indulgence. In that case, on the facts, it was in relation to 6.15, but it's the same test, and therefore we say it obviously applies, quite apart from all the other reasons why we say 7.63 applies, it applies to that too. And you'll see in the middle of paragraph 99 at D that my Lord refers to in quotes the good reason for retrospective validation, and that's using the words in 6.15.1 itself, having in the previous paragraph 98 encapsulated them in the phrase has taken reasonable steps to effect service but been thwarted. it's also made clear in 100, first sentence, that the discretion given by 615 is a very wide one.
Sorry, it's a very
Wide one. Perhaps reinforcing the importance of those rules as the only place to go for the rules on service. So tying together those submissions in relation to 7.5 and 7.6, the conclusion that we invite the court to draw from that exercise is that the equivalent wording or power that allows for retrospective extension of time in the context of the relevant 7.63 is completely absent from 6.34b. And that's where I'm going to go next.
Just before we leave good law, further to the question that my lord asked you, in relation to good law, paragraph 41 and paragraph 79 of Lady Justice Carr's judgment, she says relief from sanctions is irrelevant because we're talking about service of the original proceedings. You don't have any proceedings in which to make a procedural error and therefore need relief from sanctions when you're talking about the issuing of the claim form to start with.
Yes.
So
Well,
why isn't that a complete answer to this case?
I think the answer to that, but trying to be neutral in answering the question, the answer is that 6.34b does have the provision for the court to give permission.
Yes, and then it's a question of what the test is, as I said
Yes.
before. You say the test is 7.6, 7.63,
Yeah.
2 and 3. The test can't be relief from sanctions because good law tells us it can't be.
Yes, I mean, I obviously adopt what your lordship is saying about
just
that.
on the face of it, I mean, it may not matter, but all of the decisions that the judge refers to were all before good law anyway.
Yes. I think it's a different way of getting to the same place, but I agree that that's
It's quite quick. It has the merit of being quite quick.
Yes.
Anyway, I mean that because I mean we all often have to look at 7.6 in various contexts, and good law is the case that one comes back to again and again.
I mean, it was all an oddity that 7.6 didn't explicitly apply, as Lady Justice Carr says at 52. Reading only just between the lines, it's probably a drafting error. It's because of the peculiarities of it being a judicial review claim. But it's perfectly clear she says that the principles do. So it's really a 7.6 case in terms of guidance for how 7.6 works.
Yes. Well, I mean, one of the things, I'm going to move on to 6.342b now, because I think I need to address that. But one of the conclusions that we reached is that 6.342b may have had less thought put into its drafting than perhaps was needed. But in some ways it doesn't matter because it seems to be accepted, and the good law decision is a, as my lord says, a very good example of it, that it's a 7.63 is a self-contained code that trumps any of the other
Yes, on that
mechanisms
point,
for
though, it
getting
doesn't
around
say
it.
anything more than has already been said by she refers to the Vinos line of authority at 44.
Yeah. I mean, the Vinos line of authority is where the clarity comes from as to the inability of trumping 7.63 with a power which is not directed specifically at service. That's how we would push it, and good law is perhaps the culmination of that. Shall I move on to develop my second submission, which
Yeah.
is focused on 6.342b itself? What I'm seeking to do is to show, contrary to what's been found perhaps by the judge, but certainly is contended by my learned friend, that that provision is not part of the specific subcode for service, and I don't think it's suggested it is, and it is only concerned with effective service under that rule itself in a 6.33 situation, and does not allow a bypass of 7.63. The claimant's argument below and now is that it is a self-contained rule, presumably meaning that the court has power under it to make an order that remedies the procedural error in relation to non-filing of Form 510 and late service. He has to be able to make good. This requires a construction of 6.342, which in our submission is not available or reasonable, for the following reasons. First, if one turns it up, it's at tab 2, authorities bundle. And 6.34 starts on page 295 of the White Book. Subparagraph 1, where the claimant intends to serve a claim form under 632 or 633, the claimant must. And we suggest the use of intention there indicates a prospective act. So it's looking forward to a situation where the claimant intends to rely on the exception to needing permission to serve out, in other words, where 633 applies. And that then where 6.33 applies, it says that the claimant must file with the claim form a notice with a statement of the grounds on 633 and serve a copy of the notice with the claim form. It's practice direction 6b paragraph 2.1, which provides that the notice filed must be in form N510. The purpose of this rule, we suggest, is twofold. First, to ensure that where the claimant relies on 6.33, because it is an exception to the usual rule on service out, he must effectively self-certify that he believes the claim does indeed fall within 6.33. In other words, it puts him under an obligation, including with a statement of truth being signed, to show that this is a matter of significance to the claim and not something that casually can be done just to enable service in a foreign jurisdiction without permission. And I don't think one needs to turn it up, but
I'm just not sure what point you're making. I mean, it's obvious what the purpose is, that if you're to serve outside the jurisdiction without permission, the defendant needs to know on the basis on which you're putting your case.
That's my second reason. So that's why I said it's two purposes. The first one is to do with enforcement and policing, and I'll show you a reference by Mr. Justice Mann in the Heraeus medical case, which I think was approved by my Lord Justice Coulson in the Chelfat case about the purpose. But it probably doesn't really matter how you break this down, but this is how we've done it. You're under 633, you need to certify which ground it is that brings you under it. The second purpose is that that certification, which obviously the court needs to know too, that certification is brought to the defendant's attention, because the defendant obviously needs to understand why it is that service has been affected.
Right.
And to
challenge the premise on which it's been done. Yeah.
Just to make good the point I was making, if one turns to the Chelfat decision, which is at tab 14, at paragraph 22, And this was a case, which my Lord Justice Coulson will no doubt recall, about where the court got it wrong in refusing to actually issue the claim form because the form M510 had not been filed. In 22, the judgment quotes from Man J in the Heraeus case, and you can read that for yourselves, identifies.
Well, if you want to read it for ourselves, give us a second.
Yeah.
Okay.
And then if you go forward very briefly to 34, the same judgment. At D to E, you'll just see that this is my Lord Justice Coulson saying that the form is designed to explain why the claim has been brought out of the jurisdiction and that there are no other proceedings about the same subject matter elsewhere. So a small obvious point which my Lord has already picked up on, but that's some support for it in that authority too.
Anyway, where's all this going? This is your first reason why the claimant's case about 6342B is wrong, and you've started by saying there's rather elaborate analysis of the purpose, but what's the actual meat of your submission on this?
The meat of the submission is that the only purpose of 6.341 is to ensure that the statement or the notice, the form of 633 compliance is attached to the claim form. And I will explain why that's significant when it comes to an analysis of the sub-rule 2, which is the core one. And you'll see from the language of 6.341 that it talks about filing with the claim form and serving with the claim form.
Yeah.
The point, I'll make the point now, that the point which we say is significant about that is that it's only effective service under 633 if it's with the form, because that's how the defendant understands and so forth. If the form is not attached, the court and the defendant don't know what is required, if anything, to make service effective, i.e., because the claim form could be served in the jurisdiction, it's the point I made before, and therefore you've got no need to justify service on the defendant, or permission might be required under 636, in which case you'd have to have leave to serve it out. So all 634 is doing is ensuring that you can't serve a claim form out of the jurisdiction on a foreign defendant without giving them the notice, which has to be in the form.
Well, of course, that's what it says. But
Yes. Well, the significance is when one comes on to part 2, which is what I'm now, sub 2, which is what I'm now doing, is that we say that that analysis of 6.341 helps you to understand that 6.342 is intended to deal only with the situation where, for whatever reason, the claimant does not file the statement or notice with the claim form, and therefore there can't be effective service without the notice. And the solution offered by 6.342 is simply to provide that in that event, the claim form may only be served either by the claimant remedying it by filing the notice, or if the court gives permission. And it's clear, we suggest, that the permission provision in B is not a power for the court to grant an extension of time for service of the claim form where the deadline has expired, either directly or via the backdoor route, if one can call it that, of relief from sanction.
So is this what you're saying? It's designed to cover the case where there's no time issue, and One way of solving it is simply to reserve the claim form with the N510, which is 2A, or for the court to say, as it could say, well, look, don't bother reserving the claim form. You've already done that. But now you have served the N510, we will dispense with
Exactly.
reservice.
It's
Okay,
quite.
I've got the
I'm sorry I went round the houses to get there, but it's because there's so much stress is put on this as being a subcode by my learned friend, and I think the judge regarded it as being so. All it is a rule that allows a claimant, presumably before the expiry of the 6 months, because the whole thing is prospective, to say, I've made a mistake, I didn't file it, I have served it, and for whatever reason, maybe the form was lost, maybe the period was coming up quite close to the 6-month deadline, and the claimant thought, I'm not going to risk filing it now and just treating that as therefore service, because I don't trust the court will say that it arrived at that point in time, for example. So I'll make an application to the court and simply seek the dispensation that I've got the form now and I can just treat it as served.
So in essence, you're saying that Rule 634 is prospective and it envisages this all happening before any relevant time expiry. Hence 634(1) referring to intending to serve, and B, if the court gives permission.
Yes, that's the
You say
construction.
that's all, that doesn't suggest retrospectivity, it's all prospective.
That's how we interpret it. It possibly doesn't matter though, because even if it did allow for a retrospective application, which is this case, because this is how this claimant's chosen to bring the application.
I'm extremely sorry that the Google has conceded that it does have retrospective effect, and it's the basis on which we prepared our case.
Well, it'll be a matter for us.
Yes, my lord, of course.
What are you saying?
Even
Even if it is retrospective?
even if it has a retrospective effect, it doesn't matter because it doesn't trump 7.63.
Oh yeah, well that's...
And you know that's the centre of it's been the centre of our submission from the beginning, that you can't bypass the strictures of 7.63.
Hang on, I don't even understand the reference to retrospective effect. 2 is designed to serve a situation where the claim form has been filed, but the N510 hasn't.
Yes.
It then said, in such a situation, the claim form may only be served. So that means you've not had effective service,
Correct.
which you've always accepted, and that's the effect of 1, and is therefore the premise of 2.
Yes.
How do you solve that problem? Only 2 ways. You serve again once you filed the notice. It doesn't oddly say once you filed and served the notice, but I suspect that must be what it means.
That's also what got me thinking about whether, if you're trying to think about examples of how it would come up,
Well,
there might be a claimant who feels the need to make the application as well as filing, because having been, presumably the reason that a claimant is in the territory of 2 at all is because they've realised their mistake in not having filed the claim form with the form in the first place.
well, I think with respect, overcomplicating this, you've got a situation where you appreciate you got it wrong. Defendants pointed out, maybe you've realised for yourself. You've got 2 choices. Once you either simply serve it again, having filed the notice, or you go to court saying, can I be dispensed from having to file it? I mean, it's a faff to
Yes.
have to instruct a process server again.
Yes.
It may be fairly easy in Maryland. It may be very difficult in other countries. It may involve a lot of trouble and expense. You know it has in fact been served, and so you go to the court and say, I've now filed the notice. Please don't make me file the claim form again because we know they've already had it.
Yes, because there'd be no practical
so-
effect in doing it.
So that'd be what?
There'd be no practical effect in doing it again.
Well, there would be a there would be a okay. There'd be no point in doing it because you know they've got it. You're prepared to rely on your previous proof of service. I may be missing something, but that's a perfectly sufficient explanation, isn't it, of the requirement of permission, or not the requirement of the option of seeking, of the reference to permission.
Yes. Well, I don't dispute that at all. One's just trying to unpack what this rule is doing.
Yes.
In the face of a reliance on it, which we say, whether this reliance is correct or not, it doesn't matter in some ways because it's Trump. The fact is that this rule
Well, all right, but
doesn't allow.
Okay, but as I understand Mr. Bock's argument, he may say I've misunderstood it. It's to say that it's all very well to take your point about 763 trumps it, but that would then mean that 634 2B was redundant, and you don't assume the rule maker makes redundant rules, even in the case of the CPR. But your point is it's not redundant. It has a function, and therefore your completely distinct submission that anyway 763 is trumped isn't undermined in any way. It trumps it isn't even undermined in any way.
Correct.
Yeah.
Because
Okay. Well,
the rule is all
speaking
about.
for myself, I think I've got it. Then
Okay, well, I'm grateful. The rule is all about ensuring the service is effected. That's.
Can I just clarify? Are you saying that the last part of the second line, the claim form may only be served, is prospective only?
I'm saying that I get the prospectiveness theory, if you like, the construction, largely from 6.34.1, which talks about the claimant.
That's not an answer. I think it's rather binary. It's just I need to note your submission.
Well, I think that because of the operation of 7.63, which can't be bypassed, that this must be prospective.
But I'm obviously behind everyone else. What do you mean by prospective, and what do you mean by retrospective?
But by prospective, I mean that these steps which are envisaged here, so filing the form or applying for permission, are done before the 6-month period for service has expired.
Oh, I see. You're talking about time limits.
Yes. I'm sorry if I didn't make that clear because
Well, I was getting confused. It's obviously prospective in the sense it tells you what you have to do.
yes, no, I meant it in the context of the, if you like, the penumbra of all of this, which is the time limits in 7.5 and the rules about that in 7.63. And that one can read into this rule an understanding on the part of the draftsperson that the specific subcode on service, which includes timing, is elsewhere. It's in 7.6. It governs this.
Well, exactly. So what you said earlier, this is about effective service, what you have to do to effect service.
Yes.
And it is completely separate from any question about the time within which you have to effect service.
Yes.
That's what I've always understood your submission to be.
It
Sorry,
is.
I misunderstood all this talk about perspective.
I'm
and
sure
retrospective.
that's my fault, but
No,
that's what I meant by prospective,
Okay.
as opposed to retrospective.
And can I just ask, when 2A it says once the claimant files a notice, where is that meant to be? With the court on the other side?
That files the notice must be filed at court
Yes.
because it has to be filed with the claim form
Yeah.
in the first instance, and presumably this is envisaging the mistake where the form was not filed with the claim form. So you can remedy it, even though you've served in inverted commas. You think you've served the claim form.
Well,
But how does that help the defendant?
Yes, that picks up one of the question I asked you earlier.
Because
So suppose I serve on you in Gambia,
yeah,
and that can be quite complicated, and I don't tell you why I'm entitled to serve out of the things. As it happens, it's getting close to the 6 months. Then I just lodge at the court here, and what are they meant to do in Gambia?
Well, one's only answer to that is that sub 2 may only be served. It must be intended, as my Lord Justice Underhill said 10 minutes ago maybe, that when a claimant takes advantage of 2A and files the notice, albeit not having done it in the first instance with the claim form, the notice is then to be served again on the defendant. So the defendant
again,
has,
for the first time.
well, to be delivered to the defendant again, and therefore effective service.
Sorry, the notice that the whole situation in 2 is a situation where the notice has not. Oh, I see.
Well, it may.
So is 2. I must say I had read it as meaning where the claimant fails to file with the claim form. So it's not to do with a failure of service at all.
I think it is to do with the failure of effective service.
Sorry,
Because 1A and 1B have to be read together because you've got to file it, but you've also got to serve it.
Yeah.
yes, but
And that's when
it's
it's
very
effective.
poorly drafted if that's the intention.
I'm not going to disagree with.
It really must mean where the claimant fails to file with the claim form a copy of the notice referred to in paragraph 1A and fails to serve it in accordance with 1B, serve a copy of it with 1B. It may only be served once the claimant files and serves the notice.
Well, it doesn't say that though, does it?
No.
No, it doesn't.
And that's, for your notional defendant, I suspect it's common ground between the two of you that these are badly drafted rules, but that notionally leaves your defendant in Gambia in a difficult situation.
But practically speaking, it comes back to the caveats or the guidance in many of the authorities about the need to, including even Lord Sumption, the need to keep an eye on what happens after you file your claim form and take prospective action.
But can I just follow this through one more time? If we read this literally, and you fail to comply with 634(1)(b), you simply have ineffective service, full stop.
Yes.
And your only solution is to reserve the claim form with the N510. It goes the whole thing again.
Once you've,
Two does not give you any solution. 2 is only concerned with a different failure, which is a failure under 1A, namely to file the notice with the court. And I would have thought in terms of a workable, it's still an odd state of affairs, but of a workable system, that seems to me the better construction. Because, 2 is not really concerned with the situation we have in this case. Or, I forget, in this case, did he fail to file the N510 as well as fail to serve it?
Yes, correct.
Yeah.
And on the 22nd, it was filed. Was it also reserved? No, it hadn't been served. Was it served on the 22nd?
It was delivered again, I think. My own friend will say.
It was served. Well, it depends.
Redelivered.
It was
using the same
provided to Mountain View.
It was provided to actually to Google solicitors in London, to Pinson
Can you
Masons.
speak up a little?
Yes, my lord. It was provided to Pinson Masons.
Yes, I see.
I see. So it was provided to the solicitors
Yes.
on the 22nd, the same day it was filed.
Yes.
Though, of course,
just
at
on
that point, the solicitors were not obliged to accept service of
Right.
it.
They had no instructions to accept service at that stage.
Yeah, so are you saying it was never reserved? No, reserved is the wrong word. The N510 was never served in Delaware.
Yes, my lord, although I should say that they have never taken issue with whether or not the N510 was served. They later, they proposed to accept service on the Sphere-Drake basis, and that was later accepted.
Okay, well, we thank you, that's useful, the facts, we'll have to come back
Yes, my
on
lord.
this later. Hang on a second.
One last point that I was going to make about 6.34.2 is just, I made it in the course really of looking at the authorities, the violence line of authorities in relation to 3.10 and the identification of the specific subcode in 7.63, which is that the good reason test or the reasonable steps test that is found in 7.63 is of course entirely missing from 6.34.2b. There is no test, as I think my Lord Justice Coulson said some time ago, there's no test to be found in that rule, and we would suggest that so far as service and timing of service is concerned, it's hardly surprising because it's 7.63 that governs that.
Hang on 1 second. Thank you.
My Lord, I don't intend to say anything more about 6.34 unless you would and I can therefore move on very quickly now. I think the third submission, which I flagged at the beginning, which is the one which I said I probably wouldn't need to come back and develop, we've reached that stage. I'll just remind you of what it is. It's that it's this point that if it were the case that 6.34.2 should be construed as the claimant contends and as the judge seemed to, the consequences would be as the defendant submitted below, which the judge acknowledged had force. First, it would allow a claimant who had used 633 but left it late and missed the 6-month deadline to bypass the 7.63 strictures. And second, in other words, by falling back on 634.2, whether it be a relief from sanction, properly characterised as relief from sanction, or some other general permission in relation to effecting service under that rule. And the second is that it would put the claimant in a more favourable position, this is my policy point from earlier on, than a claimant who did not need to or had not been able to use 6.33 because the claimant was serving within the jurisdiction or because the claimant was serving outside the jurisdiction but needed permission under 636. Those two hypothetical claimants would have to satisfy 7.63, there's no question about that, to make a retrospective application to extend the time if they missed the deadline. How could it be right?
Oh, sorry, I thought you finished.
Just so, how could it be right that the 6.33 claimant would not have to?
Well, is a potential answer to that 6.34 doesn't cover anything else other than those who don't serve the N510s when they have to. I mean, why would you say that this applied generally when you have CPR 7.6?
Well, this is why I call it, I suppose, it more of a flavour of a policy reason. And a concern about there not being coherence between the rules, because it would be allowing someone who's got a 6.33 claim to avoid having to make an application under 7.63 if the judge was right, by just going under 634 2B.
Well, that's the whole point of the appeal anyway.
Yes.
Anyway,
So it's a consequence of the judge's decision and reasoning. That's why we flag it.
thank you.
And then the fourth main submission and the final one, as to why the judge was wrong, we say, is that he was wrong to find that the cases that he cited on 6.342 were an answer to the question that was before him and the arguments he heard. And again, I don't think I need to go through these cases. The two short points are, as I've said already, none of them appear to have been examples of service outside the 4 or 6 months, save possibly Athena, which I'll deal with. And the second is that in any event, in none of them is there any consideration of 7.63 and the service code. And we say that that means that those authorities do not support.
Well, the second is surely a consequence of the first.
Yes. Well, except that in Athena it is.
Well, no, except for Athena, but you wouldn't get into, unless there was a time point, you wouldn't be looking at 7.6 anyway.
No, but that was why we construed even Athena as not being a 7.6
Yes, well, that may
case.
be right. Well, anyway.
I mean, I'll just very briefly deal with Athena because I know my own friend will submit the opposite. It's at tab 11. It was not a case where 7.5 had, the time period under 7.5 had expired. And in any event, it was unusual because in a nutshell, the claimant had already served the claim form with the court's permission under 6.36, but then changed its mind as to whether permission was needed to serve out. And so the procedural circumstances, just in summary, they're found in paragraphs 41 to 51 of the judge's reasons, judge's judgment, sorry. Initially, the claimants issued the claim form under 636, believing they needed permission to serve out. They obtained permission. Service was what's described in 42 as carried out. The defendant challenged jurisdiction, including on grounds that the State Immunity Act applied and that the basis for leave to serve out had been wrongly granted. The claimant, as a result, applied to extend time for service, this is in 43, and to amend the claim form to rely on the State Immunity Act as a basis for serving out. In 46, it makes clear that service was then effected in accordance with the State Immunity Act, and the defendant filed an acknowledgement of service contesting jurisdiction. Just before that application was to be heard, the claimant changed its position to rely on 633 and contend that it didn't need to get permission to serve out, that's in 48. And it was at that point that the court notified the claimant, the parties and the claimant, that the claimant had not filed form N510 with the claim form, it technically being a requirement now that they were saying they were applying under 6.
Yes, it wasn't until the vote first.
It wasn't until then. And I don't think it was said anywhere that service was not affected initially. So the result was that the claimant applied under 6.342b, seeking retrospective permission for the claim form to have been filed with N510 or to be treated as validly served. This is in 51, and if necessary for relief from sanctions. And the court applied relief from sanction principles and allowed the application under 6.342. So you may see why we were equivocal and considered that in fact
Is this the point, so I can get in my head, that the original claim form was in time? Someone might have taken a point. Well, that doesn't matter. But that was a highly relevant point if you were going to validate the original claim using the 634 2B, when something that should have been served at that stage hadn't been served until after time had expired, namely the N510. But it doesn't look as though that point was taken. Is that right?
yeah, I think that is right. It's quite difficult to follow the procedural history.
I see. But whether it was taken or not, you can see why the whole context created a number of odd sub-questions about time.
Yes, I mean, the impression that one gets is that, I mean, the bottom line was the defendant was going to challenge jurisdiction, whether it was in response to a successful 6.36 application to serve out, which originally applied to set aside, or whether it was under the amended one under the State Immunity Act, and then correspondingly by challenging the 6.34 use of the jurisdiction of that rule. But the short point so far as this case is concerned is that none of that appears to have been based on a consideration of 7.63,
Yeah.
or even an assertion that they were out of time from the point of view of the validity of the claim form. The original claim form was served with permission very quickly, within a month, I think.
Anyway, that's your overview about why Athena doesn't help us.
Yes, and in relation to the other cases, I don't think I need to. We've dealt with them very briefly in our skeleton at paragraph 35B to C, the cases that the judge cited. But the point about them is that none of them were cases where the claim was said to have been served after the 4 or 6 month limit, and again 7.63 is nowhere referred to.
Am I being so? I'm just looking at 118, which is obviously I think what Mr. Block is saying to rely on, insofar as he relies on Athena. He says, to my mind, the words of 634.2 plainly provide a sanction for failing to file the notice. Now, is that actually accurate?
I think what it means is
Oh, I
that
see. No, all right. No, I think it is.
Service
I was
is
wondering
not
whether
effective.
You can argue about it, but a sanction is effectively where someone says your claim cannot continue.
yes,
But that, in a sense, that it's 634.1 which provides the sanction, because it says you must serve a claim form complying with these conditions.
yeah, there is an incoherence about treating it as a relief from sanction.
Yeah.
And in fact, in the next sentence, he says in context, that means that it will not be treated as having been served formally.
Yeah. Anyway, thank you. I just wanted to think that through. Yes, thank you.
So those are my submissions on the main grounds for bringing the appeal on ground 1. Ground 2, I think all I need to say is that naturally we submit it would follow that if the court were with us on ground 1, so that the judge, in other words, was wrong not to apply 7.63 or was wrong to have applied 634 as he did, that the claim, it must follow, would be...
Well, I think, as my lord pointed out, it's been conceded, hasn't it? It was virtually conceded
Yes.
below, where he said he would be in difficulties if 7.63 be applied.
And I
I
think
think
in the
we
skeleton
read
as
that
well.
Skeleton is now conceding it.
Yes,
Is that
well-
right, Mr. Block?
Yes, my lord.
Oh,
Thank you.
I'm grateful for that. So, two last very small points to deal with what my learned friend said when he got to his feet, just for your reference. This is the point about the service, in inverted commas, on Google, and the question that was asked about when that was done
Yes.
and who it was served on. We have supplemental bundle for your note, tab 13, page 147, is the, I assume that's the correspondence, which makes clear that Vincent Masons say we're not accepting service, Google is not accepting
So
service.
page 147.
147, it's not accepting service through solicitors, and then pages 151 and 152, correspondence, the Vincent Masons on behalf of Google made clear that they accepted service of the application, expressly reserving the right to contest jurisdiction, as is the usual course.
Yes, I see.
So I don't think that there is any live issue at all about service having been affected. I wasn't aware that there ever was a live
I
issue
didn't
about
think
that.
Mr. Bocker acknowledged that the N510 had never been served in Maryland. But he said it had been provided to Vincent Masons.
Yes,
And you say yes, but not on the basis that they had authority to accept service.
yes, and the
Okay.
application was issued the same day, served at the same time. My lord, may I just turn my back one moment? So, my lord, unless I can assist further, those are my submissions on the
No, thank you
appeal.
very much. That's been helpful. Well, sorry, I didn't ask my lords, but no. Yes, Mr. Bock.
Thank you.
Mr. Bock, you're rather softly spoken, and I'm getting rather deaf. So can you keep your voice up?
I will try, my lord.
Thank you.
So I'm in some difficulty because I had, of course, prepared on the basis of my learned friend's skeleton argument, in which it is conceded that 6.34 has retrospective effect and can effectively do all the things that we say it can.
Can you just show us where that's conceded? As you gather, I'm rather confused about what these terms mean in this context. I'm not saying you're wrong. I just want to see what you're referring to.
So this is, I beg your pardon, this is at paragraph 38b, page 32.
Well, I'm not sure that's well.
So it says here the defendant's position is that permission can be given retrospectively, but only where the additional test in 7.3 is met.
Is that saying that permission can be given under 634(2)(b)?
Yes.
Perhaps it is.
And in context, perhaps to avoid any confusion, I should also say, actually, before I begin, that the issue as to whether the relief from sanctions test was the relevant test has also not previously been raised. I will try to address your lordships as well as I can on these issues, but it's not; these are not points that I have prepared.
The relief from sanctions point,
Yes, my lord.
as I understood it, you're right, certainly to this extent, that the appellant said that that was at least the appropriate test, but they've also said obviously it's 7.63.
Well, they have said that
As a matter of law, that's what we're interested in, because following good law, potentially that concession, if it was a concession, was wrongly made.
well, the case as formulated by Google, by the defendant, I will refer to it as the defendant if I may, was that both tests apply. I'm just bringing out these points so that your lordships are aware of the basis upon which I have prepared my response. The other thing I would like to do before I begin is to give you the three arguments I intend to make, firstly, and secondly, I would like to take you to three documents actually. To begin with, so the arguments are, firstly, I say that retrospective permission can be given under 6.342b to not file and serve the claim form, sorry, not the claim form, the N510. That is the construction of the rule that I proposed, and that the judge below accepted, and that once that is done, 7.63 is simply not engaged. My second submission is that looking at matters in a broader context, by reference both to the purpose of Rule N510 and also the other rules concerning service, namely 615 and 616, that is a sensible interpretation, sensible purpose of interpretation. The third submission I am going to make is to take you to Rule 634 and try to shed some light on the debate that your lordships had with my learned friend a moment ago about about when permission might otherwise be given, especially in circumstances.
Yeah.
Yes. So, but before I do that, I would like to hand to you a copy, unless my learned friend objects, of the N510.
I can't believe she can object, but have you told her you were going to?
I have not, my lord. I'm sorry, but it should be.
You could have done, but I don't think it'll put you in any difficulty, Ms. Evans. It's obviously.
I was surprised to find that it had actually been left out of the
I have a
bundle.
copy.
Sorry, you were surprised.
I was surprised to find that it was left out of the bundle.
Well, presumably you had some input into what went into the bundle.
I did, my lord.
Yes, well, there we
Yeah.
are.
Can I just ask before we get into the documents and other things, you've raised, albeit in the cross appeal, 11.1. Now you're complaining they're raising new points and new constructions. This is all before us. Are you relying on 11.1 as a bar because they didn't make an 11.1 application?
Can I consider that point and give you an answer over lunch, my lord? Would that be acceptable?
Well,
I was not going to do that, but there are certainly problems in the jurisdiction complaint having been made within a relief from sanctions application, and perhaps
sorry, I just didn't hear that. There are certain problems.
There are certainly problems in the jurisdiction objections, both of them, having been made within the relief from sanctions application.
Yes, well, it's unsatisfactory this point's been raised so late anyway, and if I may say so, it's even more unsatisfactory that you're not in a position even now to tell us how you're going to deploy it. However, we'd rather have your considered submissions than unconsidered submissions. So unless my lords keep me under the table, we will defer you answering that question. But we do need to know the answer because it's in principle, in effect, how we approach the entirety of the appeal.
Yes, my lord. And
Sorry to interrupt. Can I just say that we also need to know, of course, because I'll.
Of course you do.
I may need to
When I
respond.
said we, I didn't mean only the court. Ms. Evans, you can take it that we don't regard this as very satisfactory, and you will have to make what submissions you want to make when you hear how the case is being put.
Okay, the only reason I mentioned it was on the timing, because it would be useful to know, maybe even at 10 to 2, what the answer is.
Mr. Bott, I think you need to tell Ms. Evans as soon as possible how you are putting the case.
Yes, my lord, of course.
I'm not going to press you to rush into an answer now, which you may then regret. So either way.
Well,
So-
if it assists your lordships, I do appreciate that it's unsatisfactory, and until early into the hearing, I considered that the jurisdiction issues related purely to the costs appeal. However, it seems like things have developed, including in your lordship's thinking, and that is a matter that should.
We are not trying to press you to make a point that you don't intend to take, but we do. Once we saw the point there, we wondered what its implications were. Put it that way.
Yes.
And
I don't think any of us have asked any questions of Miss Evans that goes to this point at all.
No, my lord, I did not mean to suggest as much.
no, I think probably you had in mind something I said at the very beginning, which perhaps went unnecessarily far. But you must take your own course.
Thank you, my lord, I'm grateful. So, looking at this document, this is the form N510. As you can see, all this document contains that has any importance is a tick on the second page. And what that tick represents is the claimant's reasonable belief about the basis of jurisdiction. I'm sorry, the basis for being able to serve abroad without seeking the court's permission.
Yes.
Now, as I will come back to in due course, that tick doesn't have to be correct. It's not necessary that you tick the correct box.
Well, that's an odd way of putting it. I mean, that's what's it for if it isn't necessary. Do you mean that your claim may not be a nullity if you tick? I don't know. What do you mean by it's not necessary?
In order to effectuate service, you need not tick the correct box. You need to tick a box that you reasonably believe is the correct one. But if you get it wrong, that doesn't have any bearing, according to the case law of the High Court level. That doesn't have any bearing on the validity of the claim that you bring or service. So the overarching point I was making, and I will come back to this in connection with my second argument, is that this form is a very innocuous one. And in most cases, in all cases, it is not an important or essential procedural requirement.
It's mandatory.
Yes, my lord, it's
Don't
mandatory.
get more important than must.
It is mandatory, but
And you accept in your skeleton that the failure to serve it meant that it was not valid, the claim form was not validly served.
yes, that is what Athena Capital held. That is what was held in Athena Capital.
Well, I thought you'd expressly accepted that in your
In my skeleton
skeleton argument.
Yes.
Yes, it's common ground that where a claim form is delivered without form N510, it's not properly or effectively served.
Yes.
So it may just be a tick, but it's quite an important tick.
Yes, but my point is that from a practical point of view, this is a formality that doesn't really do very much. And that is something to take into
That
account.
can't be right, can it? I mean, you are a defendant. You were served out of the jurisdiction.
Yes.
You, or more likely your lawyers, want to know whether it was a valid service out of the jurisdiction. And the first thing you ask is on what basis they're claiming to be entitled to serve under the jurisdiction. And they look at the form and it tells them. And then they say, oh, right, yes, I see, that's correct. Or they say, well, no, that may be what they believe, but they've got it wrong. We're going to make an application.
Yeah.
So I don't think it's right to call it just a formality. Anyway, in a sense, I mean, it's helpful to have the document now, but make the submissions about them later when we get to the point of your argument where they help you. So this was the first document you were going to put in.
Yes.
You said you had two others, or are they all together here?
I certainly hope so. So the second.
Yes, I see. Well, the second thing we've got is a letter from HMCTS.
That's not it. It was
Oh, I
only
see.
the.
What are the three documents then you were going to put in?
The second document is the letter before action. This is the only document I wish to put in. The others are in the bundle.
Oh, I see. Okay, sorry.
So the second document is the letter before action.
Yep.
This is at tab 16 of the supplementary bundle.
Yep.
And this was sent to Google
Page.
at page 192, my lord.
Thank you very much.
And you can see this is a letter dated 28th of June 2021. And on page 194, at the bottom, the sentence beginning finally, you will see there is a reference to the basis upon which the claim is intended to be brought in. And if you turn to tab 17, page 204, you will see this is the covering letter sent with the claim form. And you will see there in the first paragraph of the letter that the reader is referred to the letter before action dated 28th June 2021.
Yes.
So it's not the case in this case that Google didn't have notice of the basis upon which the claim was brought.
Yes, but did it say why permission to serve out wasn't required in the letter?
No, my lord, it didn't specifically say that, but if you're referring to a contractual clause, then Google would have had advice to the effect that that's a basis for not requiring permission. So the reason that I draw these to the attention of the court, and of course this was taken into account by the judge below as well, is that whilst I appreciate that it's a mandatory requirement and that it's obligatory, the reality of the situation, the practical reality, is that this is not a debate about something that has any practical implications. Now, my first argument is that retrospective permission under 6.34 obviates the need for the N510.
Sorry, I just didn't hear. Obviates the need for.
For Form N,
I see. Thank you.
Form N510. And this is because the permission given by the judge below was to not file and serve the N510 at all.
Are you going to show us his order?
Yes, Yes, my lord.
Or presumably.
Yes. Tab 6, page 50.
So where does he say that?
Paragraph 1 is it?
It must be. We obviously it's only a 2-paragraph order, so it must be paragraph 1, mustn't it?
Yeah.
Yeah.
So I'm not following that submission. I'm sure it's my fault.
I'm sorry,
The
my
judge
lord.
didn't say anything about, didn't say that Form N510 wasn't a mandatory requirement, and he didn't say you didn't need to file or serve it
Well,
in his judgment.
he says that the particulars of claim and claim form are deemed to have been served on 5th of April.
That follows the order you sought.
Yes. But you say it effectively, what he's saying, it's not phrased in this way, is that the service of the claim form, particularly the 5th of April, is to be treated as valid, notwithstanding the failure to file and serve the N510.
I would phrase it in a slightly different way, my lord. I would say that what he's saying is that the requirement to file and serve the N510 has been dispensed with.
Well, we may be playing with words here. The fact is that everyone agrees there was a requirement to do it,
Yes.
and the effect of his order is that even though there was a requirement to do it, valid service has been effected.
Yes, but it's I do beg your pardon, my lord. It's an important point.
No, of course. Please explain.
If the court dispenses with the need to file and serve the N510 at all, then what you're left with is a validly served claim form on the 5th of April.
Well, I still haven't understood. You could put it that way. If you attach importance to how you putting it that way, then we need to understand why. But I thought it all comes to the same thing, doesn't it?
I would hope so, my lord.
Yeah. Well, let's see. We may have to come back to it when we see how you develop your arguments. Yeah.
Of course, the Form N510 had been filed in any event.
Well, only much later.
No, well, but long before this order.
Yes, it had
So
been.
that had been filed on the 22nd of April. So the judge didn't need to worry about filing.
Yes.
Right. But if you
No, it was just that you said the court had dispensed with the need to file and serve the N510.
Yes. What he dispensed with was, well, I suppose you could say he had dispensed with the need to serve the N510 in advance of or no later than the service. And he had dispensed with the need to serve it altogether, or to serve a notice of it, a copy of it. And the actual language of, I think, is a copy of it, isn't it?
yes, my lord.
But I think let's not. We all know. We now have a better idea exactly what happened, thanks to Ms. Evans' submissions and your helpful intervention this morning. And we know what the judge said. Let's get on with substance.
Yes, my lord. So this is essentially my first point, that 6.34.2 gives the court a broad discretion to dispense with the need to file and or serve, as the case may be, Form N510, such that, including retrospectively, such that even if you make an application after the claim form has expired,
Can we not use the word retrospectively? It may only be me who's confused by it. You mean including out of time?
well, including after the claim form has been served. And that doesn't have to be
But
outside.
it'll always be. If it's after the claim form has been served, there wouldn't be a problem in the first place.
You mean validly served?
Well, delivered, perhaps, if I can use that term.
Problem with that is that's not a term under the rules.
Yes, my lord, I suppose there is a more fundamental problem, which is whether or not a claim form is served if it is delivered without the form N510.
Well, I think everyone agrees it isn't for the purpose of the rules.
Yes. So just to carry this point home, you have a claim form that was delivered, for all intents and purposes validly served on the 5th of April. The N510 had not been filed or served. You apply for permission. The court dispenses with the need to file and serve the form N510, and then what you're left with is a validly served claim form on the 5th of April, which is before it expires within time. You don't get to 7.63.
Yeah.
And that, I say, is a simple, elegant, and clear solution to this conundrum.
And in that sense, it's retrospective because the court's order turns what wasn't valid service at the time it was made, at the time it was done, into valid service as at that date.
Yes, my lord.
Okay.
And again, just to not to belabor the point, but the reason that you don't get to 7.6 is because 7.5 requires that it is served in accordance with Section 4 of Part 6, as I have said. And if the form N510 is dispensed with, then you have served the claim form in accordance with Section 4 of Part 6.
1 second, yes, I see.
Now, by contrast, in my submission, the solution that Google have proposed is a messy and chaotic one. And this is the notion that both the relief from sanctions test applies and also 7.6 in this case. Now, the points to make here is that well, the first point is that leads to legal absurdity, because you have a situation where you say that for the purposes of you say that or they concede that 6.34 has retrospective effect, and so if you obviate the need for the N510, you're left with a validly served claim form. So on the one hand, you have a claim form that's been served on the 5th of April, but at the same time you say that it was served out of time, and therefore 7.63 applies. And that, I say, is absurd.
Well, is it absurd? Because you could say, and Evans would say, we're dealing with completely different subject matters. Part 4 is dealing with effective service, the formalities required to achieve service. Sorry, part 4, I mean section 4 of part 6. Whereas 7.5 and 6 is a regime to do with time. and those are conceptually completely different things. Isn't that an answer to your point about messiness?
Well, if you look at 7.52, the provision simply states that where the claim form is to be served out of the jurisdiction, the claim form must be served in accordance with Section 4, Part 6, within 6 months of the date of issue. Now, in the present case, in my submission...
Sorry, just pausing there. That language, as I suggested to Ms. Evans, is not requiring you to comply with Section 4 of Part 6, because that requirement is on you anyway. The actual operative bit of 7.5 is about time, and is only about time.
Yes, but if the court has dispensed with Form N510, then you have served in accordance with Section 4 of Part 6 within 6 months, because the claim form then is served on the 5th of April. So, if you accept, as Google have done prior to this hearing, that 6.34 enables the court to give to dispense with Form N510, then the inescapable conclusion is that 7.63 does not apply. It's not engaged. So that's my first argument.
Yes.
Now, in terms of my second argument, I'm just conscious of the time being 1 o'clock. I wonder if perhaps
I hadn't noticed. If you're moving on to your next point, why don't we rise now? And if you will consider your position on the point my lord raised with you, and once you've decided what your answer to it is, let Ms. Evans know, at latest by 2 o'clock, but I think the sooner you do it, the sooner you're in a position to do it, the better. Certainly you'll need to be able to tell us at 2 o'clock.
Yes, my lord.
Thank you very much.
All right.